The arrest of the petitioner is declared illegal. The petitioner becomes entitled to compensation at 5 lakhs.
Merely because there is one cognizable offence, you go and arrest me. Because of the arrest, I have suffered humiliation. Booking.com, on which I have my listing, has written to me saying we are going to permanently cancel your listing. But if this trend is continued, then nobody can do business in India. Can the state violate the rights of accused with impunity? My simple case is,
I will definitely answer that.
Your Lordships had orally remarked on the previous statement that rape of a foreigner is a very serious offence. I just want to make one clarification. It was carried all over the media. One clarification. Yes, ma'am. I am not for a minute saying that no such incident happened or whether it was consensual, non-consensual. I'm not going into that now. The only question is whether, however serious an offence is, can the state violate the rights of accused with impunity? Yes, my simple case is.
I will definitely answer that.
Yes.
But you tell me, these homestays need to be regulated. Because
That's the function of
they
the
have
state.
mushroomed to such an extent that we don't know where are they and what happens there. So everybody's security is at risk.
No, there are thousands of homestays.
That's exactly.
We are a licensed homestay.
That's all licensed. Yeah. Gram Panchayat license kodtare. Yes.
No, can I just take your Lordship to the FIR and just point out one thing so that the state has an answer on that? Just please come to the FIR at page 37. Lord, there were 4 offences in the FIR. Please come to page 37.
Yeah, tell me.
64-1, 238, 239 and 351. 64-1 is rape. 238 is destruction.
Rape obviously is not against you.
Now, in her complaint itself, she says that the incident happened between 1 to 3. She identifies who it was. A bald man names the accused. Lord, she says 17 minutes after the incident, thank you for giving me Wi-Fi access. You are ready. You can upcharge me because you have been helping me out. That WhatsApp message, my lord, is at page 51. Your Lordship will only see at page 51. She says, thank you. I just received Wi-Fi and I'm now back up and running. Do let me know or feel free to send me a request for the dollar amount for me to pay you back. And you can absolutely upcharge me as you are helping me out. This is 17 minutes after the incident. I was not at the site at all. Now, please see, my lord, 12th. So between 1 to 3, the incident happens. 4 o'clock, I come to the property, I give her Wi-Fi. She specifically in a complaint says, I did not disclose to the owner at that time what had happened. On 12th in the night, for 16 minutes, she has spoken to her friend on call in the US. Again, 8 minutes. 13th, she herself states in her complaint that she has received call back from the same friend. 14th, she gets a call from the US consulate. She's in touch with the US consulate as well. On 13th, 14th, CCTV footage captures the family and the victim going out. We have written to the sub-registrar office in the district lot to secure the CCTV footage and keep it safe. 13th, she goes out. 14th and 15th, she goes on a solo excursion. Everything captured on CCTV. 16th lot and then 18th, the FIR comes to be registered. FIR is for 64-1, 238, 239 and 351.
Yes.
Now, on 18th evening, I'm picked up. 19th at 5 a.m., the arrest is shown. Now, Lord, all the 3 offences, which admittedly at its highest, even if they are attracted, against me are classified in the BNS as non-cognizable and bailable offences. So, on 19th at 5 a.m. when I'm arrested, I am arrested for a non-cognizable bailable offence. Lord, please remember, not in the Rajya Sabha case which your Lordships had decided, it is not my case that no FIR could have been registered. There is rape, so cognizable and mix of cognizable, non-cognizable, FIR gets registered. The question is, could I have been arrested for what is admittedly a non-cognizable bailable offence?
You're still in custody?
I'm out on custody, Lord. Your Lordships had pointed out why compensation to repair the homestay, not to repair the homestay, to repair my reputation. Lord, I have been arrested for a non-cognizable, bailable, vicarious liability has been imposed on the owner for having helped the victim. The victim has travelled with the accused on the very next day, has written. Now, please see what the parents on 13th. Just see this email communication at page 53. If Wi-Fi has been cut off for 3 days, then she's been locked in a room. Just please see page 53. This is an email communication from her parents in the US she has received, which has replied in 30 minutes. Just please see 53. Lord, your Lordship will see at the bottom the date, April 13th at 9:12 a.m. This is on the following day. If she had no Wi-Fi, she would not have received this email. She would not have replied. Just please see what the parents say. so and so, I'm not taking the victim. The urgency to connect with you is because we are very concerned about you and want you to come home safely. Your trip has taken a toll on us. Your mom is running back and forth to Haley's weekly, caring for this constant worry about you is wearing on her and me. And then she has to field calls from friends that are seeing your posts and are also very concerned. You are halfway around the world without anyone else we know in the middle of nowhere. Why wouldn't we as loving parents naturally be worried about you? Now, please mark, this is very important. Not? We don't understand why you cannot grasp that. Also, the issue with antidepressant meds amplifies this whole concern. Your Lordship, are there, Lord?
Yes, yes.
I know more than you might believe about this subject and have known many people that stop them like you did and end up in a world of hurt with extreme mood swings. Please consider going back to a smaller dose, maybe 0.5, 0.10 mg if you're experiencing negative thoughts. As far as me dismissing you, that couldn't be further from the truth, and so and so. She replies to this, Lord. That reply is at page 52. 45 minutes after this incident, she replies to her parents, which is forwarded to 7 other friends. In this entire email, there is no mention of any incident. She didn't maybe perhaps to not disclose it to her parents, but I want to only show your Lordship at page 53. I'm working, she's replying to her parents. I'm working my job right now. My work understands me and they are extremely happy for me and have blessed me too much by letting me stay here longer. And that I'm allowed to work. I don't even have to work, but they're letting me and it's wonderful. I'm able to make my American living here at least for a few weeks longer. Why is it that you want me to come back to the US so urgently when I'm learning and experiencing firsthand that miracles really do happen? God really does exist. And I'm finally, for the first time in my life, feel healthier than I ever have. No constant body pain. I have no want, thought, desire for abusive, addictive substances. My bowel movements are aligned and I'm so much physically closer to God. The unenlightened so-and-so would have continued to put up with this trend of trauma and abuse. I am finally taking a stand and being who I truly am for the first time in my life. This happens on the very next day.
You're on bail, right?
But it's not
Then-
about bail. No,
then-
it's not on bail.
then what?
Then please see this. My prayer is for a declaration that the arrest is illegal to stay the FIR insofar as 64(1) concerned against me. No, it's not about bail. There are pre-arrest safeguards and post-arrest safeguards. I'm not coming saying that my post-arrest safeguard of a written grounds of arrest is not given me, therefore it's violated. The pre-arrest safeguard is, Lord, if an offence is punishable less than 7 years, you should give me a 35(3) notice, comply with Arnesh Kumar. I'm not even saying that has been breached. That is admittedly breached. Something more serious, the breach is, there is a jurisdictional bar to arrest somebody for an offence which is non-cognizable. 35(2) is a non-cognizable offence. 35(2) says there is a bar on the police to arrest for a non-cognizable offence. How is it that, however serious this offence is, whether she's an Indian or a US citizen, merely because there is one cognizable offence, you go and arrest me? Because of the arrest, I have suffered humiliation. Booking.com, on which I have my listing, has written to me saying, we are going to permanently cancel your listing because there are sexual misconduct allegations against you. Lord, vicariously, Lord, the owner, Lord, if this trend is continued, then nobody can do business in India. Whatever has happened, whether regulation should happen or not, that is state's responsibility, executive's responsibility, they're doing it. They need to crack down on homestays which are operating without license. We had a license, we have done the due diligence, we have done it. There's an unfortunate incident that's happened.
Well, see, yes, see.
At 5 a.m. I'm arrested. At 11:30 in the night, I'm produced before the magistrate, not for remand purposes. At that time, 3(5) is added in the remand application for the first time. 3(5) is common intention to rape. I'm not even in the site. Supreme Court says 2 things to invoke common intention. There has to be prior concert and there has to be physical participation. That's the only way on which they've arrested me.
Well, see. Yes,
We are not saying there is a common intention to rape. We are saying common intention to destroy the evidence. We are saying common intention to threaten the witnesses. The very fact that my learned friend has received the copy of the grounds of arrest. We have said what is the allegation against him. If he is not taken advantage of that and then wanted to come here and cry, we can't help. We have very specifically said what is the allegation against him. And the grounds of arrest we have served to him. The copy is there and shows that what is the allegation against him. That's one. Second, my learned friend is speaking about depression. Is he saying that she was not subjected to sexual assault? I'm sorry.
No,
I started
depression
with
is a separate thing. That has nothing to do with what he's
Started-
wanting to project. That is accused number 1 will.
No, I started
not
by
accused
saying,
number one.
I'm
There are
not
two
for a
people.
minute saying,
No, in fact, not
I'm
one.
not for a minute saying
Not
that
one.
there is
There
no
are two
rape.
people.
There's someone arrested, he's in custody. The question is not whether an allegation of rape can stand against the owner.
Well,
Admittedly,
We are
when
not
on the
saying.
com-
Will
We are
answer.
not. We are not.
On a summation of the preceding analysis, there is no warrant of interference at the stage of crime, and the result, the prayer with regard to the quashing of the crime is sans acceptance. The arrest of the petitioner is declared illegal. the petitioner becomes entitled to compensation for such illegal arrest. The criminal petition is allowed in part. The arrest of the petitioner is declared illegal. The petitioner becomes entitled to compensation at 5 lakhs on such illegal arrest. The state shall pay the aforesaid compensation within 4 weeks from the date of receipt of the copy of the order. The challenge to the FIR in crime number 34 fails. It is imperative that investigation should continue. Liberty is reserved to the petitioner to knock at the doors of this court in the event they is agreed with the final report. You're already before the court. It's all right. Yes.
I'm so grateful. I'm so grateful.
It will release now. Idu.
Today's hearing concluded with an important order from the Karnataka High Court in the Kodagu homestay case. Justice Nagaprasanna has refused to squash the FIR at this stage, making it clear that the police investigation must continue. However, the court held that the arrest of the homestay owner was illegal and directed the state of Karnataka to pay him ₹5 lakh as compensation within 4 weeks. The petitioner had challenged the FIR registered after an American woman alleged that she was sexually assaulted by an employee of the homestay. He had also sought ₹15 lakh compensation, alleging violation of his fundamental rights. While the court declined to interfere with the criminal case, it found merit in the challenge to the manner of his arrest. Notably, the final charge sheet has dropped the offences of rape and criminal intimidation against the homestay owner, though other allegations remain under investigation. With this order, the High Court has drawn a clear distinction between allowing the investigation to proceed and protecting an individual's constitutional rights against an unlawful arrest.